right, we're going to start. I want to welcome you to hear a very, very special guest speaker, Colonel retired Richard, although known to everybody as Dick Jackson. We're very, very proud and pleased to have him come here to speak at Hall. He's currently the Special Assistant to the U.S. Army Judge Advocate General for Law of War Matters, and he's done that since 2005 when he retired from the U.S. Army after 30 years in uniform. He has extensive experience in the law of war and international operational law, and he told me to shorten his bio, which is a little hard for me to do on the cuff. I will just mention some of the places in the world where he's worked, including Bosnia, Panama, Haiti, Kosovo, and Iraq. He was chair of the International Operational Law Department of the Army JAG School in Charlottesville, Virginia. And he's written extensively in professional publications and lectured around the world on law of war matters. And those of you who are in my class, particularly in my seminar, you know some of his writings as well, that you've been assigned to read for today's class. So you can ask them some questions. From 2010 to 2013, he was the chair of the Libre Society, interest group of the American Society of International Law. And again, those of you who've taken my classes should be familiar with the idea of the Libre Society based on Franz Libre and the Libre Code itself. Colonel Jackson is currently a member of the board of the U.S. Committee of the Blue Shield, an NGO dedicated to protection of cultural property during armed conflict. And I will put in a little bit of a plug here for the U.S. CBS. If you're interested, there are some flyers outside on the table where you check in. However, the caveat is I was told don't worry about it, but the address there listed is no longer relevant, but the web address is. So just look at the web address and you'll be fine. Dick Jackson is also an adjunct professor at Georgetown Law teaching the law of armed conflict seminar. Amongst many of his articles, as I've already mentioned, he's a contributing author to The War on Terror and the Laws of War, published by Oxford University Press in 2009, The Law of Counterterrorism, published by the ABA in 2011, and the Aspen Case book, The Law of Armed Conflict and Operational Approach, published in 2012. So with that, just before he starts, I want to thank both the Center for Art, Museum, and Cultural Heritage Law, and particularly the Associate Director, Lubna Elgendi, for organizing the visit. And I want to thank CIPLIT, the Center for Intellectual Property Law and Information Technology, and its Executive Director? Okay. Ellen Gutiantoff. She recently had a promotion, so I wasn't sure of her new title. I want to thank CIPLIT for co-sponsoring and helping to organize the event as well. So with that, please welcome our speaker, Dick Jackson.
Thanks, Patty, Professor Gersten, for inviting me here, and also for the opportunity to come in at lunchtime and talk to you guys. I'm looking forward to our class this afternoon. How many of you are in that class this afternoon? Okay, good. So I'll try not to talk too much about what we'll talk about this afternoon, which is cultural property protection in armed conflict, but it's an important area of my practice, although what I consider a niche portion of my practice, because I practice as the Special Assistant to the Judge Advocate General for Law of War Matters. I practice on the issues regarding the law of war, and we consider the 1954 Hague Cultural Property Convention and some law, which I'll talk about this afternoon, as an integral part of the law of armed conflict. But it's an area near and dear to my heart. In 2009, we ratified the 1954 Hague Cultural Property Convention. That's a pretty long time to get something treaty ratified. And Patty, the Lawyers Committee, the ABA, and the State Department were instrumental in getting that convention through the Senate finally at a time of great opportunity to get treaties passed, because it's a difficult thing in the U.S. government to get a treaty passed. And then in 2009, I was the DoD representative at the first States Parties meeting at UNESCO in Paris, where we made an opening statement presenting our ratification to the body of state's parties, and talked about all of the work that Patty and some other people I'll talk about today have done in the last 10 years to raise cultural property protection up to the level that is appropriate and consistent with the 54 Hague Convention. So it's an area I call niche practice, but it's very important to me. What I'd like to do today is kind of give you an idea about what JAGs do. As Patty said, I spent 30 years in uniform, and of that time, about 7 of it was in the infantry or in law school. My infantry time was as a infantry platoon leader, a mortar platoon leader, a heavy mortar platoon leader, and a tactical officer in officer candidate school. So what I was doing was getting newly commissioned officers into the Army and preparing them to do their job. And while I was at officer candidate school, teaching and acting like a drill sergeant for officers, I applied for the funded legal program. Went to the funded legal program for 3 years in Georgetown University. Did my summers at a place you'll get to know very well, Fort Belvoir, Virginia, each summer, and got my introduction to the JAG Corps. Now, we also have an internship program that some of you are familiar with that for law students who will eventually be directly commissioned into the JAG Corps if they're interested. And that program involves doing what I did those 2 summers, going to a law office somewhere around the United States or even overseas, and doing intern work, practicing the practice of law at the entry level in military JAG offices. Now, what I'd like to do today is first give you a little bit of an idea about what JAGs do and how they do it, what JAG career patterns are like. Now, we're lucky we have an active duty JAG in the office or in the audience today who can answer even more questions and more recent questions about what JAGs do. But part of my job is to provide support to folks in the field, so I try and keep a line on what's going on out there in the field and visit folks in the field when I can. And part of what I didn't have Patty read is the last 10 years I was in the JAG Corps, I was a staff judge advocate, which is the senior lawyer at various Army organizations. First, it was at the U.S. Army Special Operations Command at Fort Bragg, with all of the Army attorneys that are involved with special operations, civil affairs, and psychological operations under my supervision. Second, it was at the 25th Infantry Division in Hawaii, where we had 28 attorneys and responsibility for all the military Army real estate in Hawaii. And then the third staff judge advocate job was with Multinational Division North in Bosnia, where I took our division and our JAG shop to Tuzla in Bosnia for a deployment there. After that, I returned to Hawaii, where my family stayed as I was deployed, and I was the U.S. Army Pacific Staff Judge Advocate, which has responsibility for the JAGs within the Pacific region. That includes Alaska, Hawaii, Japan, Korea, other forward deployed areas. And finally, my last Staff Judge Advocate job was with Joint Forces Command Naples with NATO. So I had an experience in joint and combined JAG positions, and was able to watch young judge advocates grow in each one of those positions. And it was, frankly, the most interesting and important function of my JAG career was training and mentoring judge advocates, captains. Well, they start out for a little while as lieutenants and then work their way through for about 5 years as a captain, and even some young majors that I had an impact on as a staff judge advocate. And my philosophy as a JAG leader was to help people develop in the ways that they wanted to develop, but through the various JAG disciplines. And we have, like any other legal profession or practice of law, we have specific areas of law that we practice. When I started out as a JAG in special operations, 5th Special Forces Group was my first assignment, I was what we call a jack of all trades. I did legal assistance 2 afternoons a week. I was the trial counsel for that unit, so I tried all of I was the prosecutor, I tried all of the cases that came out of that unit. I did administrative law for that commander. And I did contract and fiscal law when that was required, especially when deployed. And finally, I did claims work when we were deployed. And then I got a great deal of opportunity to practice operational and international law that we'll talk about some more. So all of the JAG disciplines are an opportunity for JAGs that first start out. And then many people do what I did, which is try and concentrate in one or two areas of the law. So I concentrated as a criminal law expert, so I did trial counsel, I did defense counsel, I did chief of justice work, which is a manager of the prosecution function, and then of course as a staff judge advocate, I cycled through a lot of cases supervising the prosecution function. And then the other area of expertise and interest of mine was one that I've been able to pursue since I left the active duty military, which is operational and international law. And we'll talk a little bit about that. Most people manage their own careers. And that's because there isn't a puppet master in Washington, D.C. that makes sure that you do everything that you're meant to do in life. So you find your own opportunities and you pursue them. And the Army, as probably the biggest law firm in the world, is a great place to do that. And it's also a great place to serve your country. Any questions about what JAGs do and the career options that are available for JAGs? Okay. Let's talk about the area of my specialty, at least especially my specialty for the last 10 years, and that's international and operational law. Now I lump a number of different parts of international law in here. International law consists of pure international law, which is negotiation of treaties, interpretation of treaties, and advice to the commanders that have to apply those treaties. So we have an international law shop in the Office of the Judge Advocate General that just deals with status of forces agreements and other international agreements. The international agreements that I focus on are those related to the law of armed conflict. And so the law of armed conflict is very much positivist law. It's law that's written down in treaties. Customary international law has, at least from a state's perspective, has much less to do with creating the obligations of states in international law than does the treaties that states sign up to. So what I do is develop policy and assist commanders in interpreting the law of armed conflict defined in treaties. But treaties also have very specific application by their terms. For example, the Geneva Conventions apply during international armed conflict between two states. Just defining what's an armed conflict is the subject of much debate recently. And my experience as the JAG on the ground in a number of cases, including in Panama during Operation Just Cause, was that sometimes the national authorities have a hard time figuring out what the state of the law is and what they're obligated to, and whether or not we're in an international armed conflict or a non-international armed conflict. Let me give you an illustration. I'm the senior defense counsel in Panama in December of 1989. I go outside my house in the canal zone and look up, and there's this sea of helicopters passing over my head. And it's December 20th, the night of December 19th and 20th of 1989. And those helicopters are taking American soldiers to objectives, to military objectives at the beginning of Operation Just Cause. And I didn't know much about it. I mean, I was a defense counsel. I was defending soldiers who were involved in committing all sorts of crimes. And the operational security mandated that we not know much about what was going on in the operation. But the staff judge advocate called me up and said, there aren't a lot of people to defend in the next couple of weeks because they're going to be busy. So would you go to Empire Range Base Camp and be the legal advisor at the prisoner of war camp that we were establishing here. So I picked up my Field Manual 2710 and my Army Regulation 190-8 that gives some guidance in that area, and my law board desk book from the JAG school, and I took it out to Empire Range and started to assist the company commander of an MP company in administering that prisoner of war camp. We eventually had thousands of Panamanian Defense Force prisoners of war, I would characterize them, and many others who were picked up. Noriega opened up the prisons and just let folks out. They opened up the insane asylums and let folks out. So the soldiers who were in Operation Just Cause had to go and police those folks up, and we had to figure out what to do with them. But I called up the guy that was in my position, Hayes Parks, in DC, and I said, Hayes, what kind of conflict is this? You know, that's an important question for deciding how to apply the law, because the law says you've got to figure out what kind of conflict you're in to figure out what law applies. And then you got to figure out what kind of person you're dealing with. That's what we used to teach at the JAG school, was what kind of person, what kind of place are you practicing this law? Those are the initial questions you have to ask. Well, Hayes started tap dancing. Didn't we swear that guy in, that president in, the night before the invasion? So he invited us in. So it was a foreign internal defense mission. Well, that's kind of ridiculous. I mean, just from the facts. We ousted the de facto government of Manuel Noriega and put in place the government we thought was properly elected as the president of Panama. But it looked, you know that phrase, if it walks like a duck and talks like a duck, it looked like an international armed conflict. I mean, one nation's forces fighting against another nation's forces. We were seizing people we considered as prisoners of war. And oh, by the way, there isn't much law for non-international armed conflicts. There's a sliver of law, of that treaty law, that applies to non-international armed conflicts. So I said, Hayes, you know, I know at the policy level you're dealing with some difficult issues, and there's a whole lot of political implications involved with characterizing a conflict, but what we're going to do is I'm going to follow the law I have available to me, which is the law of international armed conflict. And so there's a whole Geneva Convention focused on prisoners of war. So that's what we applied. And that's what all of our doctrine and policy was written and focused on, was the Third Geneva Convention for Protection of Prisoners of War. Give that all as an illustration to make this point that what we've decided to do as a nation is to apply the law for international armed conflict across the spectrum of conflict, no matter how you characterize it. That's so the soldiers in the field have a standard they can train to and a positive set of laws that they can apply, no matter whether angels are being debated and dancing on a head of a pin at the national level, or even no matter whether there's some dispute about whether or not there's a gap between the third convention and the fourth convention. You may remember there was that debate at the beginning of the Iraq War about whether or not unprivileged belligerents somehow fell into a no-law zone. So since that time, since 2003, what we've done is told the folks in the field they apply the standards for international armed conflict across the spectrum of conflict, no matter how that conflict is characterized. And that includes situations of conflict that don't involve two armed forces of a state going against each other, like peacekeeping operations. If we detain people in peacekeeping operations, we'll treat them consistent with the Prisoner of War Convention, even though the Prisoner of War Convention doesn't technically apply. That's the way to get around things like the torture memoranda that were developed in the early 2000s, and to keep our soldiers focused on doing what's right in terms of treatment of people in the hands of a party to the conflict. Okay, Additional Protocol 1 and Additional Protocol 2 were developed in 1977. So you'd think by now we'd have some definitive U.S. answer to whether or not we apply those two protocols. Additional Protocol 1 has some really important law in it. In fact, all of the law of targeting is now well placed and well established under Additional Protocol 1. But shortly after 1977, in the early 80s, we decided as a government that certain provisions of Additional Protocol 1 were so onerous that we could not sign Additional Protocol 1. President Reagan sent a transmittal letter for Additional Protocol 2 over to the Senate in 1986 and said, let's sign Additional Protocol 2, but we had no intention of ratifying Additional Protocol 1. Now there's really two provisions in Additional Protocol 1 that are onerous as far as the U.S. government's concerned. One is recognizing wars of national liberation and wars against alien occupation as being the same as international armed conflicts. You got to get some context to understand that point. In the 70s, there were still a number of wars against colonial powers going on. The Portuguese, for example, still had a number of colonies throughout Africa, and there were insurgencies going on against those colonial powers. That's not so much the case anymore. There really aren't colonial powers subjugating foreign nations now. But alien occupation has been an issue since 1967 in the West Bank, and so it still comes up as an issue. And the U.S. government's position was that elevating the status of insurgents, sometimes called terrorists by states, to the level of the equivalent of a state was not appropriate. For various reasons, most of them political, but also practical. For example, how do you tell that an insurgent is a combatant, a lawful combatant? First of all, if they're an insurgent within a recognized government, calling them a lawful combatant is contrary to national law. Nobody has the right to overthrow by force their own nation. So So there's that problem. But also there's the practical problem of how do you identify them as a combatant. Insurgents who work from the people, under Maoist theories of warfare, they swim like the fish in the sea of the people. They're very difficult to identify and distinguish from the civilians that we're sworn to protect. So Additional Protocol 1 has that problem. And then it has the problem in Articles 43 and 44 of recognizing combatants as, even if all they do is carry their arms openly as they're attacking. Now that's the distinction problem also, because if an insurgent launches his attack from the people, from a sea of the people, and then pulls his weapon out only at the last minute, then the force that's defending has a very difficult time distinguishing between the civilians, again, that they're required to protect, and the military, and the insurgent. So that's the reason why Additional Protocol 1 has not been forwarded for ratification. But there are huge portions, except for those three provisions I told you about, that have been so well recognized and practiced by states that they deserve recognition as customary international law. And so I'm working on a project that is in part designed to do that, and it's called the Department of Defense Law War Manual. Now, folks that hear that phrase that are in the military laugh. Sometimes they're polite and they just smile, but the project has been going on since I joined the JAG Corps. I mean, when I was in the advanced course in 1986, my predecessor, again, hosted a meeting of the Empire Club, our allies from former British colonies and Great Britain, that were developing a law of war manual, and it still isn't published. So we're hoping to have that published, according to Mr. Preston from DoD General Counsel, by July of this year. So that project is going to, in part, define what are the parts of AP1 that we accept. AP2 deals with non-international armed conflict. Okay, anybody in here read Hamdan? Have you heard about it? Hamdan 1, really. Okay, Hamdan is a Supreme Court case from 2005 that says that we're in a non-international armed conflict with Al-Qaeda and associated forces. Now, what Hamdan was dealing with was military commissions, but it was dealing with application of Common Article 3 to the Geneva Conventions, which is that tiny sliver of law that applies to non-international armed conflicts. And what the Supreme Court said was, so simple as to be surprising, that, look, if you're in an armed conflict, you're either in an international armed conflict between states, or you're in a non-international armed conflict. And now the Common Article 3 was developed with the history of the Spanish Civil War in mind. Okay, it was developed in 1949, and you read the Travaux Preparatoires, the legislative history of that treaty, and it says that they were thinking about how do you deal with applying the law of armed conflict to internal armed conflicts, to traditional civil wars, like the Spanish Civil War. But the Supreme Court came up with a very elegant solution to this problem, and they said, even if it's a non-state actor that you're fighting against across international boundaries in what some have called a transnational armed conflict, if you're in an armed conflict, you apply the rules that are available for the minimum standards that are available in a non-international armed conflict. So we apply Additional Protocol 2 and Common Article 3 in a non-international armed conflict. We have signed Additional Protocol 2. We've 3 times sent it to the Senate for ratification, including the Bush, Clinton and now Obama administrations, and the hope is that we'll get that signed sometime in the next millennium. I mean, Professor Gerstenbluth looks at me quizzically over that because she knows how hard it is to get a treaty through the Senate. But just consider the UN Convention on handicapped individuals. You know, that adopted a U.S. standard for dealing with the disabled, and said, hey, these are great best practices, why don't you use them across the world? And the Senate just went crazy about it and said, no, that's establishing a one world government, we can't be doing things like that. So treaties are very difficult to get through, but additional protocol 2, at a minimum, by the Vienna Convention on the Law of Treaties, we're required to act consistent with additional protocol 2 because we've signed it and indicate our intent to ratify it. So that's our other approach, and we're also working in that manual to look at recognizing it as customary international law. The Lex Specialist debate. Anybody pay attention to the U.S. statements at the Human Rights Council on Friday last week? Come on, I gotta have 1 or 2 human rights lawyers in here. Nobody? Anybody taking human rights law? Wow. Because just about every law school I go and talk to, there's always a group that is focused on human rights law. Human rights law arose at the same time that these major treaties regarding the law of armed conflict arose, after World War II. And I say they arose from the same font. I've taught human rights law at the University of Maryland, and I taught it from Ryan Goodman's excellent text on human rights law. And they say the same thing. And you can find many of the same provisions of human rights law in the law of armed conflict. In fact, Common Article 3 and Additional Protocol 2 adopt a series of prohibitions that are entirely consistent with human rights law that we agree to apply to our own citizens. In Additional Protocol 1, Article 75, the President announced in March of 2011 that we consider that Article 75 of Additional Protocol 1 as being applied to us as a matter of law, out of a sense of legal obligation, which is the magic language for establishing opinio juris, one of the 2 requirements for customary international law. Article 75 of Additional Protocol 1 is entirely taken from the International Covenant on Civil and Political Rights. So it's human rights standards that apply in armed conflict, and we've accepted it as customary international law. So there's a great deal of overlap between the 2. Well, on Friday, the chairman of the Joint Chiefs of Staff Legal Advisor, Brigadier General Rich Gross, was in the background as the State Department representative presented to the Human Rights Council the current U.S. position on international human rights law and its extraterritorial application. The U.S. a number of years ago, when Harold Koh was at the State Department, went to the same Human Rights Council and said we would study whether or not human rights law would be applied extraterritorially. The decision that we went through after studying it was that we would continue not to apply it extraterritorially unless we have, by legislation, said that we intend to apply a statute extraterritorially. Why is that? It's because the root of human rights law is different in many ways from LOAC. The same sentiments are there, but human rights law has been generally just applied between a state and its people. It's a way to regulate the conduct of states with respect to their own people. And in negotiating the ICCPR, Eleanor Roosevelt, who was the U.S. representative at the negotiations, said that we would apply the ICCPR to persons in our jurisdiction and in our territory. Okay, there was a conjunctive used in the treaty. That conjunctive is part of the treaty. So the U.S. position has been that it has to be someone who is in our territory and under our jurisdiction. So we don't apply human rights law unless there's another source, like the law of armed conflict treaties, extraterritorially, unless we've got a statute that says so. So, for example, the Detainee Treatment Act. As I said, there was some clarification needed as to the application of certain provisions of the LOAC regarding torture and outrages on personal dignity in the 2003 to 2005 timeframe. The Detainee Treatment Act makes those standards applicable both in armed conflict and outside of armed conflict, but extraterritorially. So, and that's what our ratification documents for the ICCPR also said, is that first it wouldn't be applied extraterritorially, and second, the ICCPR would be applied either through the lens of our Constitution, remember American exceptionalism and its impact on international law, and second, through legislation that specifically applies laws extraterritorially. So you look at, for example, a criminal law, assault or murder of a U.S. official overseas has to have a jurisdictional hook in it that says this applies overseas, as well as the special maritime and territorial jurisdiction of the United States, like on U.S. vessels and enclaves overseas. Okay, so that Lex Specialist debate is about what law applies in armed conflict. And there's an ICJ nuclear weapons opinion that says that this question is not a question of conflict of laws. It's not a question of whether human rights law applies or LOAC applies. It's a matter of Lex Specialist. What's the most specific law to apply in a given situation? The nuclear weapons case says that the general Lex Generalis, or the general law to apply, would be the prohibition on arbitrary deprivation of life. That's in the ICCPR. But the Lex Specialis in armed conflict is the targeting law from Additional Protocol 1 I just talked about. You apply the principles of distinction and proportionality in targeting during armed conflict. That's the more specific law that applies over the general law of arbitrary deprivation of life. You'll see a great discussion of this in the white paper, the leaked white paper that was leaked to, I think, NBC regarding the targeting of U.S. persons overseas. It's never been released publicly, but there was a white paper released that has some discussion of this concept of Lex Specialis in it, if you read between the lines. Okay, the other big issue that flows from this is targeting and drone strikes. Anybody have any strong visceral views about drones? Sir?
Yes, the question I have, which I'm sure you'll cover, is what exposure do we have where the drones are being run by civilians rather than active duty military?
That's a question really of, for me, of who's my client. My clients are military personnel and the U.S. Army. So that's an issue, but not one that I have. I really have no point. No place in having a personal opinion about it on this stage. What I will say is that we prohibit civilians from using, from targeting with drones. So we have a DoD directive called Civilian Workforce Mix that takes an inherently governmental function approach to that issue and says that the decision to target is an inherently governmental function. Now that's also derived from the law of war, because the law of war requires that the use of force be supervised by a military chain of command. So that part of the decision to apply POW status, for example, is whether or not you're a part of a chain of command that can apply the law of war and can enforce that application of the law of war. So, so we don't let civilians, that's civilian employees of the military or contractors, do targeting with military drones. Now, other agencies I can't really talk about and I really don't know about. Yes, sir?
I was going to ask about the other agencies.
Yeah, like I said, I mean, there's been a lot of public discussion about that issue. Gary Solis has written a great op-ed piece about it, if you want to look that up. And it's been the topic of a number of American Society of International Law roundtables. But I work for the military. I don't work for an intelligence organization. So and it hasn't been publicly acknowledged that that CIA is targeting people. Pardon me?
Was that a pun?
An unintentional one, yes. Okay. So no other real visceral problems with drone targeting, ma'am?
Well, obviously, totally naive, coming out of nowhere. I'm not really sure that I believe what I'm told, that the drone is going to be as specific as it might be. I assume there's going to be loss of life around the target.
Yeah, I've sat in tactical operations centers, and I've watched video screens. Video screens from H-64 Apaches, video screens from UAVs, unmanned aerial vehicles, video screens, live streaming from other aerial platforms. And my experience, and I'm sure that my colleagues in the room that have also done this, is that it's the most accurate and law of war compliant means of using force. I mean, you compare, I said I started out as a heavy mortar platoon leader. You compare what a 4-deuce mortar can do, they were pretty accurate. I mean, we won awards for our accuracy in using those 4-deuce mortars, but they're not anywhere near as accurate as the UAV capabilities and the other capabilities that include live video feeds, because you just can't compare the ability to figure out the pattern of life around that area. The UAV loiters for a long period of time, provides intelligence, surveillance, reconnaissance for, and you get many different means of surveillance and reconnaissance on those targets. And you can integrate them in the tactical operations center. So you get signals intelligence, the guy's on a cell phone or a walkie-talkie. You get other imagery from elsewhere. So it's as good as it gets. And all of you have seen from maybe the first Gulf War period and since, you know, pictures from aircraft, from Air Force aircraft of following a bomb down. We now have GPS capability called Excalibur, all the way up to 155 artillery. That's amazing. You know, I reviewed that in 2007. That gives you the accuracy of about 10 meters, worst case, of GPS. So, in terms of accuracy and preventing collateral damage or civilian casualties and damage to civilian objects that are not military objectives, that is unmatched. Now, how other agencies do that, I can't swear to, but I just recently read a report that drone strikes in Fatah, by everybody's view, during 2013, didn't have a single civilian casualty. So that's pretty darn good in terms of collateral damage. Yeah.
I guess I'm wondering if you could clarify what you mean by visceral reaction when you ask us for a visceral reaction about drone strikes.
Well, sure. Sometimes I get, when I talk about this with non-governmental organizations, for example, I get the conflation of drones with autonomous weapon systems. So people think that drones are killer robots from the sky. That's the kind of visceral reaction I'm referring to. And they're not. I mean, there's a human in the loop with UAVs and drones. Or they're really called drones, or they're referred to drones in popular literature. But the military actually calls them remotely piloted vehicles to emphasize the point that there's a human in the loop that's using it. Another kind of a visceral reaction that you read about in the popular press is taint fair. You know, it's the concept of chivalry, that you ought to be facing your opponent in the face and dueling it out with swords or something in order to accomplish a military objective. That doing it from 10,000 feet in an F-16 or from only 1,000 feet in a UAV is just not chivalrous. You know, technology has extended our military capabilities for a long time, and I think that's ridiculous. If we can accomplish a military mission without putting more of our American soldiers, your brothers and sisters and uncles and aunts, in harm's way, then I'm all for it. Yeah.
Well, then I disagree with you, but that's my visceral reaction. It's probably not the right place to.
Well, no, I invited it. You know, I really.
I'm a classicist by training, so there's something to when you read something like the Iliad, where you have being able to see someone face to face when you're killing them puts a human element into your enemy, which the further you draw back dehumanizes further who your enemy is. And you can say there's a human still piloting that, but it becomes more and more like a video game, and that human interaction between the two combatants is lost, and therefore we separate ourselves from what it means to kill another human being.
Well, and that's a very important point, and also one which has been addressed not only in the popular literature, but is addressed on a daily basis with our operators. And there's really two responses to that. The first is that the law of armed conflict is intended to regulate a very inhuman activity. Killing others, breaking things, but part of the purpose of the law of armed conflict is to make it so that the person doing it, the operator, can still be a human being and go home knowing that they did what they did in accordance with the accepted standards that society and their government has. They're taking a life based on the authority of the government. They're not doing it on their own. They're doing it in a way and with the government authority that they're given. And so we want the soldier who is on that UAV directing that remotely piloted vehicle to be able to go home and say, look, shave the next morning and look himself in the mirror and say that they did it in accordance with the law of armed conflict. Okay, that's an important point about LOAC. But second, the interviews with people that do this mission, whether it's from Creech Air Force Base in Nevada or from the various forward operating bases in Afghanistan, have to an individual said that is a very human and very impactful decision on the operators, and they think about that all the time. And in fact, they may know that person better than the sniper who's up on the hill, because they watch him go into his house at night and have dinner with his kids on the roof, and go in and out of the neighborhood and associate with their neighbors. So it may be more human and a more intimate association than you suggest. Sir?
I just want, we only have 5 minutes.
Okay. Sir?
What do you do with the situation where the other side is deliberately using a shield with the population?
Human shields are a real problem. We've tried to build that into our policy guidance over the last several years. But the law of armed conflict has reciprocal obligations. Obligations on the enemy and obligations on the attacker. And the enemy has a responsibility to separate himself from civilians and civilian objects. So part of it is on him, on the enemy that places the civilian at risk. But be that as it may, we still have a requirement to use the most discriminate method possible and to avoid collateral damage. Beyond that, excessive in relation to the concrete and direct military advantage gain. That's the standard under proportionality of Additional Protocol 1. So it's a difficult problem, and quite frequently the decision not to use force is made rather than to take a civilian life. You could see that as part of the factor in that white paper I referred you to.
Would standards change if you actually had a declared war through Congress?
We have a declared war, in my view, the authorization for use of military force, but standards change based on the tactics of the enemy, yes. So if we have an enemy that violates the law of war frequently like that, then there will be more civilian casualties, inevitably. But it's still important to avoid them, but also for political reasons involved in the conflict itself. So if you have a counterinsurgency going on, or you're trying to restore the lawful government, like in Panama that I described, killing the civilian population hurts that end state. So you want to avoid that as much as possible. I want to cover really quickly implementation of Hague 54. I covered it briefly, but it's still something we're struggling with in the military, because it's more than just about targeting, as you'll hear if you come to the class this afternoon. It's about protection of cultural property as you go into conflict, as you go into an occupation or counterinsurgency operation, and it's about establishing professionals to do that. So I commend to all of you to go see Monuments Men about the precursor of the professionals established in 54 Hague, which is the Arts and Monuments teams of World War II. And comparative law and rule of law efforts are a big deal these days for us, although less so as we're no longer so much involved in long-term stability operations. And I've covered a number of these issues over today, but investigations and prevention of civilian casualties really deserves some additional discussion. I'll stay around to answer questions if we have it, if you have it. And deployed criminal justice is an important part of the operational law function, because we enforce the law of armed conflict through prosecutions. So US v. Bales is an example of that. Lieutenant Colonel Morse prosecuted Bales and got a life sentence for him for killing civilians near Kandahar province in Afghanistan. It's deployed criminal justice, though, has a lot of challenges. Think of collecting evidence on the battlefield. Think of maintaining your witnesses and getting them to court. And then the witness, the issues of dealing with witnesses with a totally different cultural view of the crime. Colonel Morse used a Afghan-American to illustrate this point in my class, my LOAC class at Georgetown. And Mawari, who's both his girlfriend and an expert in cross-cultural communication, gave a fantastic presentation on convincing those Afghan witnesses to come and testify at the sentencing hearing. So that it's just another example of how different and difficult it is to apply the law on the battlefield, which is what operational law is about. Okay, I'll hang around for questions, but do we have any time for any additional questions?
Well, I'm gonna, we'll conclude, so students have class at 1. Is there a class in here? Okay, so we can hang around for a few minutes for questions, but in the meantime, I want to thank you very much and ask everyone else to thank you.